Ms. Jacoby?
Mr. Chief Justice, and may it please the Court, knowing and voluntary pre-sentence appeal waivers are enforceable bargains, and no doctrine of contract law calls for a different result based on the subsequent sentence that the defendant receives. Petitioner asks this Court to create new substantive limits on the enforceability of those knowing and voluntary waivers, but he's provided no administrable limits on which waivers should be in or out. The litigation that would inevitably follow under his frontline approach would essentially eliminate all appeal waivers. As a fallback, petitioner proposes a safety valve to appeal waivers for the most egregious sentences. But without more real-world evidence of the most far-fetched hypotheticals, this is a solution in search of a problem, and it's a solution that comes with costs. An amorphous exception for egregious sentences will also invite litigation over what is egregious. Such litigation will deprive the government of the benefit of its bargain, thus making appeal waivers less valuable as bargaining chips for defendants. In all events, this Court should make clear that there is no exception that would permit petitioner's appeal, rather than simply remanding as petitioner suggests. No injustice would be worked by dismissing petitioner's unripe due process claim, but remanding would signal doubt on that score to lower courts and litigants, opening the floodgates to garden variety waived appeals like petitioner's. Finally, this Court should reject petitioner's argument as to the second question presented. The district judge's statement that petitioner had a right to appeal was accurate under the terms of the waiver and circuit precedent, but even if it were not, the government's non-objection to a misstatement by the district court did not modify or waive the party's written appeal waiver. I welcome the Court's questions.
If this Court says that the agreement is void, would a remedy that would eliminate the underlying agreement be that you totally eliminate the plea agreement?
Yes, I do think there is a possibility that if this is, this is an essential part of the bargain, and if we are not getting our part of the bargain, then we don't have to enforce our end of the bargain either. I think petitioner has argued that the possibility that we'll, reinstate the dropped charges is enough of a disincentive to stop the floodgates of dismissed appeals, but, of waived appeals. But in practice, that's not actually much of a deterrent because it's not an option we avail ourselves of all that often, because our whole point in bargaining for an appeal waiver is we want to bring finality to the proceedings and we want to stop spending resources on it. So the idea of having recourse to go back and reinstate the charges is kind of at that point.
So in this case, though, just confining it to this case, what's the disincentive to allowing an appeal here?
I mean, that is our whole concern, is that if you open the floodgates to sort of a broad miscarriage of justice exception, there isn't really a powerful disincentive, and we will, in various cases, be deprived the benefit of our bargain because we'll have to be litigating whether this exception, amorphous exception to appeal waivers applies.